Current Trends Case Brief. Human Rights Tribunal of Ontario. Smith versus London Police Service Board. Citation: Smith versus London Police Service Board, 2014, HRTO 158. The applicant Travis Smith filed an application under Section 34 of Human Rights Code. He is claiming that an officer discriminated against him with respect to goods and services because of age. Smith and a friend were in Farmsboro Park sitting on a playground equipment. Officer Constable O'Brien and his partner were on a routine patrol with the purpose of dissuading unlawful activity in the geographic locations outlined by Project Learn. The park has a curfew of 10 p.m. In the park, the officers issued him and his friend a provincial offense notice with a fine of $65 for violating the Section 2 of Trespass to Property Act. Smith was 19-year-old. He alleges that the officer ignored another older couple in the park and only targeted him and his friends due to his age. He alleged that Project Learn targets college-age students and that the officers were patrolling with the intent to target college-age students. He also alleged that the officer treated him in a rude manner. Issue number 1. Did the officer discriminate in providing services to Smith by treating him differently or targeting him for mistreatment because of his age? Number 2. If discrimination occurred, what is the appropriate remedy? Decision: allegations in the application are dismissed. Rationale: firstly, there is no reason to conclude that the officers would have not stopped had the applicant been an older individual in the park at the time. The officer had issued trespassing tickets in this park in the past to both students and non-students. He would have issued a ticket to anyone who had happened to be in the park after the curfew. Secondly, there is no sufficient reliable evidence to establish that there were other persons in the park at the time of this incident, or, if there were, that any such persons came to the attention of Constable O'Brien. Thirdly, the officer's behavior in issuing the ticket was routine. No comments regarding age were made. Therefore, the applicant's age was merely a factor that led the police to issue him a trespassing ticket, but there was a non-discriminatory reason for the respondent's actions. Smith was in the park after curfew, which was unlawful. Smith's belief that he was singled out due to his age is not evidence but a mere assumption. He has not met his burden to establish that he was treated differently because of his age or otherwise discriminated against based on his age. Moreover, the case clearly shows that how one felt is not the major factor in considering discrimination in the legal sense. Thus, the allegations are simply dismissed. Though the situation was upsetting to the applicant, they are not considered as discrimination in creating justice. The decision to dismiss the allegation in the application is therefore appropriate. Survey question: do you think that if the applicant were not a youth, the respondent would have acted in the same manner and treated him the same way?